Good evening. Today we are going to discuss the new laws which have been brought by the Ministry of Home Affairs, how they are going to affect the common people, the Aam Janta. The government claims that they are going to be more victim centric. The victim can participate. The victim can also ask for information. Earlier, we had seen, there have been cases many a times where victims have said that they have gone to the police stations and the police walas have refused to register FIRs, citing that the scene of crime, does not fall in their jurisdiction. But now, with these new laws, that is the Bharatiya Nyaya Sanhita, a zero FIR can be registered anywhere, regardless of where the crime has happened. So, this is a very big step as far as this new law is concerned. And also, in this new law, a victim is entitled to know as to how her investigations are progressing. Many a times we have seen cases wherein victims, especially women and children, they keep running from pillar to post trying to find out where their cases stand, but nobody gives them information. But now, as per the new law, a copy of an FIR should be given to her as soon as possible. And as far as the investigation progress is concerned, within 90 days, she should be told as to how her case is progressing. So, this is again a big step as far as the cases relating to women and children is concerned. Another aspect which has been introduced is regarding sexual crimes, regarding sexual exploitations, rapes, or gang rapes. Many a times we have seen that victims, they have recorded their statements, but the accused party, when the case goes for trial, the accused party tries to exert pressure on her, saying that you should either withdraw from the case or change your statement. But now, in this new law, that is the BNS, her statement would be audiographed and also videographed. This is being done so that the accused party cannot put pressure for her to change her statement and cannot use this loophole for their own advantage. So, again, this is a big step as far as women and children are concerned. The technology is being used to help them. Each and every process of her, whether it's the case diary, whether it's an FIR, would be digitized, would be electronically digitized, so that the records are kept properly. Many a time some documents go missing. Again, the accused gets some kind of a favor, and ultimately he gets relieved or he gets acquitted. But now even the technology, even the forensics are going to help the victims. Secondly, the second big thing which has been changed in this new law is regarding hit and run cases. We have seen earlier there was not a clear demarcation as to what is the culpability. But now, as per the new law in the hit and run cases, a person, if he causes an accident and flees from the spot, that is the crime scene, then he would be given at least 10 years of imprisonment. But if he stops and tries to help the injured, then the quantity or the quantum of punishment would be lowered. So again, this is a case, or this is a new thing which has been introduced, which will ultimately help the people, because again there are many hit and run cases, there are many accidents which are taking place. Thirdly, this is mob lynching. Earlier, mob lynching was not clearly defined in any of the IPC or the CrPC, but now it has been clearly defined. In fact, when the Union Home Minister today was making a statement as far as mob lynching is concerned, he also targeted opposition, because earlier opposition was targeting the government, saying that they won't be introducing this law because this law ultimately would affect them, because many cases have been registered as far as mob lynching is concerned in the states where BJP rules. So the Union Home Minister, Mr. Amit Shah, took a you know a tease. He teased Mr. Chidambaram, saying that you have been ruling this country out of 70 years. In 58 years, you have been ruling, but you did not make any changes. But it's the Narendra Modi Sarkar which brought the changes. Now, mob lynching would attract death penalty. So, any case wherever it's registered would be clearly defined, and it would attract mob mob lynching would attract death penalty. That is another big thing which has been done in this case. Another thing which is there, cases relating sedition are not going to be registered, because now sedition has become deshdroh. So a new terminology has been introduced in the system, in the BNS. Now it would be known as deshdroh. Earlier, any person who used to say anything against the state would or was booked by the police officials. But if you target the unity or the integrity of the nation, then only you would be targeted, or a case would be registered against you. The Union Home Minister today, gave a detailed reply in Lok Sabha. He said that he got as many as 3,200 suggestions came to him from various faculties, which also included the chief justices of the states, and also IPS community, the collectorate system, because these are the wings of judiciary, or the executive, which are going to implement these laws. So all these suggestions were taken. In fact, the Union Home Minister sat in 158 sittings himself before any kind of finalization was done as far as these three laws are concerned. He also said that technology is going to be used tremendously. Forensic science is going to be used. There's going to be a timeline also, because earlier the cases used to keep dragging on, and the police always used to say that we are doing investigation, we are doing reinvestigation, and they used to take a lot of time. But now, as per the new law, every FIR would, even if it contains a small case, within 3 days the police is bound to register an FIR. And if a crime attracts a sentence of 3 to 7 years, after initial investigations of 14 days, an FIR would have to be registered, and also charge sheet would have to be filed within stipulated days of 180 days. After 180 days, the police could not take a plea, would not be able to take a plea that they are reinvestigating the case, and the magistrate would be asked to take cognizance of a case within the 14 days after the charge sheet has been filed. Another interesting fact which has been introduced in BNS is trial in absentia. We have seen many a times, in many cases, accused are not in India, they are abroad. In those cases, the trials keep lingering on. But now, as per new law, within 90 days, if an accused does not present himself before the court, then the government prosecutor can go ahead and the case would proceed. So this is again a very big step as far as reforms in criminal justice system are concerned. And within 45 days of after the case is heard by any judge, the pronouncement of sentence, or the pronouncement of have to be done, because earlier we had seen many cases in which the judgments have been reserved for years and the judges have not pronounced sentences. But now a stipulated time period has been given by the law. In fact, the Union Home Minister also gave as to how many changes have been done as far as Bharatiya Nyaya Sanhita, that is the CrPC is concerned, the Suraksha Sanhita is concerned. Earlier, there were 531 laws, 484 laws, sorry. Now they have been increased to 531 laws. Also, 9 new laws have been introduced, 39 subsections have been introduced, and 44 new provisions have been introduced. Similarly, in IPC, that is the BNS, earlier 511 laws were there, which have been reduced to 358. 21 new laws have been introduced. 82 cases, the penalty cases have been introduced. Also, 6 cases have been introduced, or 6 sections have been introduced, which attract community service. So for the first time, community service would also be there as far as reforms are concerned. The Union Home Minister also said that the definition of terrorism has been introduced for the first time in BNS. This is again a big move by the Modi government, because earlier only the special laws, either it's UAPA or the MCOCA, used to define terror laws. But now in BNS, the terror laws would be defined. This is being done. Although the opposition was claiming that there would be some kind of duplication, but the Union Home Minister claimed that this would not end up duplicating efforts, but rather, in many states, these special laws are not there. So many a times accused are booked under normal CrPC and they get the benefit and they do not serve the entire sentence. But now, since law would be there, the uniformity would be there, so similar law would run in the entire country, and an accused won't be able to take this, use this loophole for his own advantage. Also, then they said that as far as these digitizations are concerned, video recordings would be done. Then these forensics would also be increased. As many as 2,000 crores has been sanctioned by the government of India. 30 states, many forensic labs are coming up. The idea is to take the conviction rate, which is very low as far as heinous crimes are concerned as of now, especially women related crimes are concerned. But now, since the evidence would be collected forensically and also preserved digitally, so they assume or they feel that the conviction rates would increase in coming days. They hope that the conviction rate in coming days would be up to as high as 90%. Another big law change which has been introduced: earlier in 19 offenses only a person could be declared as a proclaimed offender, but now as many as 120 offenses have been introduced in which a person can be declared a proclaimed offender. And lastly, which again is a very big step by the government, many a times we have seen that prosecution sanction was very hard to get, as to prosecute any civil servant or the government official. But now a provision has been introduced that if a permission does not come, or if a rejection does not come in 120 days, then it would be assumed that that civil servant can be prosecuted. So obviously the accountability as far as civil servants and the police officials are concerned, it will also increase in these new laws. Changes are going to be seen, because we have seen, me as a crime reporter has covered crime for so long. I have always defined laws, whether it's murder it was 302, or whether it's attempt to murder it was 307. But now the government says the priorities have changed, and that is why now body related crimes and also crimes related to women and children are first, and that's why murder would be defined in section 101. And as far as rape is concerned, earlier it was defined in the section 375 or 376. Now it would be defined in section 63 and 69. So obviously the priorities have changed. The government says that the the laws have changed, and now the focus of the government is to get justice to the common people. So thank you for watching this. I hope I would be able to help you in breaking down this complex issue.